Hello, everyone, and welcome to another episode of the Forge of Freedom podcast. I'm your host, Alex Ooley, and this is episode 140 of the Forge of Freedom. Today, I've got a bit of a Supreme Court recap to some degree, and I'm not going to talk about everything the Supreme Court has done this term, but I want to talk a little bit about some of the things that happened here at the end or near the end of their term. Of course, they finished up yesterday with the opinions. Of course, the big news yesterday was the presidential immunity case, which will directly impact, of course, the cases pending against former President Donald Trump. But I'm not here to talk primarily about that case. I wanted to focus more on the firearms-related cases and then talk more generically at the beginning here, at the outset, about the Loper Bright case, which we have mentioned from time to time on this podcast previously, anticipating that the court might rein in some of the administrative overreach that we've seen for decades now, and especially in recent years with respect to firearms. So in the Loper Bright case, the court issued their opinion in that case, eliminating Chevron deference. And what is Chevron deference, you might ask? Well, Chevron deference is a judicially created doctrine that gives deference, that gives the benefit of the doubt, so to speak, that gives sort of self-governance almost to administrative agencies, which are not branches of the judiciary, are not typically branches of the legislature, although there are some administrative agencies that are creatures of the legislature, but are primarily or generally creatures of the executive branch and are tasked with enforcing the laws created by the legislature. The problem is that these administrative agencies have stepped beyond their enforcement authority and into really into rulemaking and reinterpreting laws in a way that are essentially legislative in nature, and then also into the judiciary function, because if they get to interpret their own actions and the courts are supposed to give them deference, then essentially they become extrajudicial in a sense. So they have basically spanned the three branches of government and have become this all-powerful branch, fourth branch of government, and an unelected branch. So they're almost, not quite, but almost entirely unaccountable, accountable only indirectly through our vote for president and for various legislative positions. So anyway, in Chevron, the case from 1984, the court said that in interpreting an ambiguous statute, the court should defer to the executive branch agency, to the agency authority that's tasked with enforcing the particular law. And because they're presumably the experts in the particular field. If it's the with respect to alcohol, tobacco, and firearms, it's the ATF that's tasked with policing or enforcing the laws with respect to alcohol, tobacco, and firearms. If it's the EPA, it's the EPA that's tasked with enforcing the laws with respect to the environmental regulations and laws. And so these are the so-called experts, and we saw how that rule by experts went, especially during the pandemic years. It was quite a disaster. And it has been really for decades under Chevron as well, because these agencies have basically exploded in their scope, their authority, and their size, and primarily because of Chevron deference. And these agencies, and I'm just going to put this up here on the screen for those of you watching by video, they're almost too numerous to count. In fact, I don't believe there is an official number of federal agencies. And here I'm just talking about federal agencies, not administrative agencies that may exist at the state level. But here you see on the Federal Register at federalregister.gov a list of 439 agencies. Okay, so this is a huge list of just federal agencies. And you can see if you do a search, alcohol, you'll find well down the page, alcohol, tobacco, firearms, and explosives, the ATF, and the DEA, and Immigration and Naturalization, and United States Marshal Service, and so on. And you have a list here of 439 agencies. And so these agencies were given the benefit of the doubt when the legislature passed a law and there was some ambiguity in the law, their interpretation of it, of that law, or even if the law was silent, their interpretation of the silence in the law, and that's what actually was at issue in the Loper Bright case, was given judicial deference. So the court wasn't interpreting the law or interpreting the ambiguity in the law. It was these administrative agencies tasked with enforcing and interpreting. And so the Loper Bright case involved a case challenging some enforcement provisions by the National Marine Fisheries Service, NMFS, which required fishing vessels, to carry a federal observer on board. You might ask, why am I talking about this? And many of you know why, if you've listened to the podcast before, why I'm talking about this. This is not a firearms case. It is a more broadly freedom-related case, but it's also indirectly related to firearms as well. So the NMFS required these fishing vessels to carry a federal observer on board to comply with their regulations and the regulations under the Magnuson-Stevens Act, the MSA. Well, not only did they require these fishing vessels to allow these monitors on board, they also required them to pay at least a portion of their salary, a significant chunk of money for many, especially smaller fishing vessels. Well, guess what? The statute didn't provide for that, or at least it was silent as to how it was implemented by the NMFS, the National Marine Fisheries Service. And so these plaintiffs, brought by the fishing vessels and the various the companies and fishing vessels themselves, they challenged the agency interpretation of the law, of the silence in the law about how these federal observers were to be paid. So these boats, these fishing vessels, had to pay to have the federal government monitor them. Okay, that's quite a service. This is supposed to be a government of the people, by the people, for the people, and it seems like in this circumstance and in many others, it's a government for the government, where we serve them rather than the other way around. And so they challenged the deference that the courts had been giving to administrative agencies like this, and the case went all the way to the Supreme Court, and the Supreme Court issued an opinion that did away with this deference, this Chevron deference that was established in the Chevron case in 1984, and had been cited thousands of times in the intervening years. And so this was a case, the Chevron deference, that had massive influence on administrative law, allowed the expansion of these agencies to a huge degree. There was this huge body of law built up around it. There were law schools that had courses dedicated to administrative law with huge bodies of law to study, and for academics to do papers on and study and talk about how they were going to effectively regulate us, the people. And finally, the Supreme Court gets a case and eliminates that massive government usurpation of power. Chevron deference, like I said, was a completely judicially created doctrine. It was made out of thin air. It was invalid from the beginning. And some of the criticism of the Loper Bright case overturning the Chevron doctrine or deference was that it would undo this massive body of law that's built up over the intervening years. And of course, that's got nothing, just because you've been doing it wrong forever doesn't mean it's right to continue doing the wrong thing. And that's essentially what it comes down to. And then also that these administrative agencies are going to be curtailed in the means and scope of how they are able to regulate and exact tyranny. That sounds like an exaggeration, but it's really not, on us, the individual citizens of the United States. So this is a huge case. I'll link to it, of course, in the show notes. But it's important because, like I said, it's not a firearms case. It's not a Second Amendment case. It's an administrative law case. But this has huge ramifications for that list that I have up on the screen of agencies that involve themselves in all sorts of areas of our lives. And so these agencies are not going to have carte blanche to sort of self-regulate, which they is a stretch. They don't really regulate themselves. They just usurp authority. Okay, so this is going to have wide-ranging effects on all of these agencies going forward. And then couple that, and I'm going to put up a few tweets here in just a moment, or posts on X. One from Spike Cohen, who I follow, and I encourage you to follow as well. He's got some great content on X. But couple this Loper Bright case with the Corner Post case, which was also decided by the Supreme Court this term, which basically said that the statute of limitations doesn't apply in a case where a person sues a regulatory agency for damages if their damages are recent. So let me rephrase that. It said that in Corner Post, Supreme Court said that people can sue regulatory agencies for damages even after the statute of limitations expires if their damages are recent, or even if the regulation is decades old. And I think if you couple this Corner Post decision with the end of Chevron Deference and Loper Bright, I think that signals a lot of lawsuits coming down the pipe against these out of control regulatory agencies. And so I think that's great news. Of course, that will cripple these regulatory agencies to a large degree, and I'm here for it. I think that's a great thing because they have grown beyond the bounds of what the founders ever imagined, beyond what was ever contemplated by the Constitution, and they fundamentally violated the separation of powers, the structural Constitution between the legislative branch, the executive branch, and the judicial branch. All right, I'm going to put up this tweet here by Spike Cohen, and then we're going to talk about a few other cases, more gun-related cases. But I'm just going to read this to you for those who aren't watching the podcast by video. For those who don't understand what Chevron deference is and why SCOTUS ended it, SCOTUS, of course, is Supreme Court of the United States, here's the long and short of it. A family fishing company, Loper Bright Enterprises, was being driven out of business because they couldn't afford the $700 per day they were being charged by the National Marine Fisheries Service to monitor their company. The thing is, federal law doesn't authorize NMFS to charge businesses for this. They just decided to start doing it in 2013. Why did they think they could get away with just charging people without any legal authorization? Because in 1984, in the Chevron decision, the Supreme Court decided that regulatory agencies were the experts in their field, and the courts should just defer to their interpretation of the law. So for the past 40 years, federal agencies have been able to interpret laws to mean whatever they want, and the courts just go with it. It was called Chevron deference. and it put bureaucrats in charge of the country. It's how OSHA was able to decide that everyone who worked for a large company had to get the jab or be fired. No law gave them that authority. They just made it up. It's how the ATF was able to decide a piece of plastic was a machine gun. It's how the NCRS was able to decide that a small puddle was a protected wetlands. It's how out-of-control agencies have been able to create rules out of thin air and force you to comply. And the courts had to simply defer to them because they were the experts. Imagine if your local police could just arrest you for any reason and no judge or jury was allowed to determine if you'd actually committed a crime or not. Just off to jail you go. That's what Chevron deference was. It was not only blatantly unconstitutional, it caused immeasurable harm to everyone. Thankfully, it's gone now. We haven't even begun to feel the effects of this decision in courts. It will be used for years to come to roll back federal agencies, and we'll all be better for it. And that's why politicians and corporate media are freaking out about it. So I thought Spike Cohen here put it more succinctly than anybody, how straightforward and how wide-reaching this opinion will be. And I think it could even have an effect at the state level as well. I think there will be challenges to state administrative agencies that are engaged in the same sort of regime. So we'll put that away there. And then I also agree, Dave Benner commented on Spike Cohen's post on X. He said, "My gut says that overturning Chevron deference will yield far more liberty than the result of the 2024 presidential election, despite getting far less attention." I think he's probably right. The fact is, these administrative agencies are one of the largest components of the deep state. And even though Trump, who avowed that he would that he would drain the swamp, struggled to do that. But I think that this case will do more to accomplish the draining of the swamp anyway than the president of the United States could. So I think this is great news. I also think, by the way, that this case rivals and probably exceeds the impact on liberty as compared to Bruin as well. Of course, Bruin was the decision by the Supreme Court in June of 2022, that affirmed that Second Amendment challenges would be subject to this text, history, and tradition analysis, and that overturned the New York law that required good cause to obtain a license to carry a firearm in New York. I think that Bruin will have a significant effect, at least as it pertains to firearms. But I think that Loper Bright will have a much more broad effect, even within the realm of firearms in the Second Amendment, but well beyond the Second Amendment. So I think that Loper Bright is, in my opinion, much more significant even than Bruin. Okay, so we talked about Loper Bright. Of course, Loper Bright, I think, will have a significant impact on the ATF and a lot of the shenanigans that the ATF has been up to, whether it's the frame and receiver rule, the engaged in the business rule, the definition of a firearm is, what the definition of a machine gun is, all these things where the ATF is inserting themselves, reinterpreting statute that is clearly a statute in a way that's clearly not consistent with the plain language of the statute. And I think that Loper Bright will have a significant impact in those cases and reining in the ATF. So with that said, I think that the Loper Bright case was the biggest news from this term of the Supreme Court. Of course, Rahimi was a big case with respect to the Second Amendment and whether or not the Second Amendment allowed for someone subject to a domestic violence restraining order to be a prohibited person, and whether 18 U.S.C. 922 G8 in particular was constitutional as applied, at least to Rahimi. But that was a much more narrow decision than the Loper Bright case. While I think it was a loss for the Second Amendment, the Rahimi case. It could certainly have been much worse. And of course, I'd encourage you, and I'll link to this in the show notes, to go back and listen to my episode specifically about Rahimi if you're more interested in that. But then there were these people following the Second Amendment in the Supreme Court were wondering, would the Supreme Court take up any other cases for consideration in the fall? And there had been a number of cases pending review by the Supreme Court. So there'd been a petition for certiorari, petition for review. The Supreme Court had relisted a number of those cases for conference on a number of occasions, which means they're considering what to do with those cases, how to handle those cases, whether to grant review, grant cert, deny cert, or GVR, grant, vacate, and review, where they say, and this is what they did on a number of cases. We've decided a case that may be relevant to the issue in this other case, so we're going to grant cert, we're going to vacate the opinion of the lower court, and we're going to remand it back to the lower court to reconsider the case in light of this other decision that we've made, primarily this term, the Rahimi case. And that's what happened with a bunch of cases. I believe it was 8 cases that the Supreme Court ordered today to be GVR'd, granted review, vacate the decision of the lower court, and remand it back to the lower court for further consideration in light of the Rahimi case in particular. And there were basically 3 categories of suits that the Supreme Court didn't basically refused to consider on the merits and sent them back to the lower courts. And that was based on these cases involving prohibitions on persons, places, and things. And the first category is cases that were challenging federal prohibited persons bans in a number of categories. Particularly, the one of interest, most interest to me at least, was this nonviolent felons case, which was the Garland v. Range case, which involved, I think, a check fraud, and which was clearly a nonviolent crime, and whether a nonviolent felony would be constitutional, prohibiting a person from possessing a firearm would be constitutional. The court remanded that case, GVR'd it, remanded, ordered the court to consider it in light of Rahimi. So I anticipate that a case like that will make it back to the Supreme Court, but the Supreme Court did not take up that issue, at least at this time. The other case that the Supreme Court GVR'd in light of Rahimi was the Antonyuk case, which challenges New York's Bruin Response Bill, which basically made every place in New York a sensitive place, a place that was off limits. So they said, okay, well, because we can't prohibit people from obtaining a license, arbitrarily prohibit people from obtaining a license to carry a firearm, we'll just make every place in public off limits. In some places, not in public, off limits from carrying a firearm. We'll make them so-called sensitive places. Well, the Supreme Court did the same thing with that case. They GVR'd it. They granted review, vacated the lower court's decision, and remanded it to the lower court for further consideration in light of Rahimi. And of course, Rahimi was a prohibited persons place. This is a sensitive places case, so it's not directly applicable, but Rahimi did reaffirm the analysis from Heller, reaffirm the analysis from Bruin, and shed some light, although not much, on the methodology from Bruin. So the lower court is supposed to consider what Rahimi said about that methodology in their reconsideration of Antonyuk. And then finally, the ones that a lot of folks were interested in, including me, is this category of cases, or collection of cases, I should say, from Illinois challenging the Illinois assault weapons ban and so-called high-capacity magazine ban. Of course, those are propaganda terms. These so-called assault weapons, AR-15s, and standard capacity magazines involve the most common rifle in America and would certainly meet the definition of an arm in common use under the Heller case, and then affirmed by the McDonald and Bruin case. And the Seventh Circuit is essentially just thumbing their nose at the Supreme Court by upholding these bans. And unfortunately, the Supreme Court didn't take these because they were interlocutory appeals. So that means there was no final judgment at by the lower or in the lower court, and they were appealing preliminary injunction, whether or not there should be injunctive relief, which means basically the law gets put on pause until the case is resolved on the merits, until it's fully litigated. Well, the Seventh Circuit said, nope, we're going to let the law stay in place while the case is fully litigated. And the plaintiffs appealed the Seventh Circuit's determination that the preliminary injunction would be denied. And so this case was not fully litigated by the time it was petitioned to the Supreme Court. The Supreme Court ordinarily does not take those sorts of cases on an interlocutory basis. Although there was good reason to do so here, the court nevertheless decided not to take these cases until they were fully litigated. And that may be partly because the trial court judge here, or one of the trial court judges anyway, Judge McGlynn from the Southern District of Illinois, set an expedited trial date, I think in September of this year. So we should have a final judgment in the trial court in at least one of these assault weapons cases, assault weapons ban cases in Illinois by the fall. And maybe the court knew that, the Supreme Court that is, and decided we're going to let this play out at the lower court level before we decide the case on the merits. And Justice Thomas wrote which is not, it's not unusual, but there aren't very many, where a justice opines about why they denied review. And so here, Justice Thomas was in agreement that the Supreme Court would not grant review of these assault weapons ban cases, but nevertheless wrote, sending a message, wrote basically a note saying that the state of Illinois, and I'll put this up on the screen here actually, bear with me so you can see it. The state of Illinois enacted a law that makes it a felony to possess what Illinois branded, quote, assault weapons, end quote, a term defined to include AR-15s. The AR-15 is the most popular semi-automatic rifle in America and is therefore undeniably in common use today. Petitioners sought a preliminary injunction against the enforcement of the law, arguing that the law violates their Second Amendment right to keep and bear arms. The Court of Appeals for the Seventh Circuit rejected petitioners' request for a preliminary injunction, concluding that the AR-15 is not protected by the Second Amendment. According to the Seventh Circuit, the rifle selected by millions of Americans for self-defense and other lawful purposes does not even fall within the scope of arms referred to by the Second Amendment. This court is rightly wary of taking cases in an interlocutory posture, but I hope we will consider the important issue presented by these petitions after the cases reach final judgment. So Justice Thomas here is indicating that he wants to consider these issues if the Seventh Circuit, as we all anticipate, screws it up. He's anticipating that the Seventh Circuit here is going to wet the bed and he's going to have to clean up the mess. We have never squarely addressed what types of weapons are arms protected by the Second Amendment. To be sure, we explained in District of Columbia versus Heller that the Second Amendment's protection extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. And we noted that the Second Amendment does not protect those weapons not typically possessed by law-abiding citizens for lawful purposes, recognizing that the historical tradition of prohibiting the carrying of dangerous and unusual was consistent with the historical tradition. So notice it says carrying of dangerous and unusual. So if it's in common use, that automatically makes it not unusual, makes it common. So it can't be dangerous and unusual if it's common. But this minimal guidance is far from a comprehensive framework for evaluating restrictions on types of weapons, and it leaves open essential questions such as what makes a weapon bearable, dangerous, or unusual. The Seventh Circuit's decision illustrates why this court must provide more guidance on which weapons the Second Amendment covers. And this is the good part here. By contorting what little guidance our precedents provide, the Seventh Circuit concluded that the Second Amendment does not protect militaristic weapons. It then tautologically defined militaristic weapons as those that may be reserved for military use. The Seventh Circuit's contrived non-militaristic limitation on the arms protected by the Second Amendment seems unmoored from both text and history. And I'm not going to read the rest here. You can read it if you'd like. I'll link to it in the show notes, of course. But I will finish up here. He says, it is difficult to see how the Seventh Circuit could have concluded that the most widely owned semi-automatic rifles are not arms protected by the Second Amendment. He says, if the Seventh Circuit ultimately allows Illinois to ban America's most common civilian rifle, we can and should review that decision once the cases reach a final judgment. The court must not permit the Seventh Circuit to relegate the Second Amendment to a second-class right. So even though the court didn't take up this issue, at least Justice Thomas sent a message about how badly the Seventh Circuit had already screwed this up. So that's a pretty strong message in a denial of a petition for certiorari, saying basically, hey, we are going to take this on the merits once there's a final judgment in the lower court. And so that's good news. And then the final thing I want to mention here, there is one firearms-related case that's already accepted by the Supreme Court for the fall. That's the Garland v. VanderStok case. And that's, of course, considering whether a weapons part kit that is designed to or may readily be completed, assembled, restored, or otherwise converted to expel a projectile by the action of an explosive is a firearm. And basically they're saying, and this is an ATF, a problem with the ATF again, whether a hunk of metal that still has to be machined, that still has to be manufactured essentially, is a firearm. And the Supreme Court will be reviewing that case in the fall. In fact, there have already been a number of briefs filed, some amicus briefs, and so the briefing in that is going on as we speak. So anyway, I hope this helps make some sense out of what has happened, at least in part, at Supreme Court this past term, where we're going in the future. Of course, Rahimi was a big decision. I think the Loper Bright was the biggest decision. I encourage you to go read it, because really the Supreme Court opinions are written in a way that are pretty much in plain English. There's not much that you wouldn't be able to understand as a non-attorney. So definitely go check those out, especially the Loper Bright case. And we'll hope that the Supreme Court addresses some of these other issues coming before it in the near future. Obviously, there are lots of anti-gun efforts to restrict the right to keep and bear arms based on age, based on sensitive place, based on what constitutes an arm under the right to keep and bear arms, and lots of other methods as well. And one way in particular is the argument that I've seen a number of times, especially with respect to these bans targeted at AR-15s, is with respect to the common use test. Of course, they're commonly owned, but are they in common use? And they're saying if they're not actually used in self-defense, and because they're not commonly used in self-defense, as in a high percentage of people who own them don't actually have to use them, actually fire them in self-defense, that means they're not actually used in self-defense. Of course, that's an absurd argument to make, but that's one tactic that the gun control community has been taking. So, of course, I think the Supreme Court's going to be busy with respect to Second Amendment litigation. As you know, if you've listened to my previous episodes about the Second Amendment, about some of the litigation around the Second Amendment, there really hasn't been much litigation around the Second Amendment until 2008 when Heller was decided, and then 2010 when McDonald, and then really until recently after the Bruin case, because there was almost nothing going on between McDonald and Bruin for 12 years. So that's going to be heating up in the coming years, and I hope that the Supreme Court continues to carve out some more freedom for us folks that enjoy the right to keep and bear arms. Of course, we're not, as I've shared before from the 10th Amendment Center, it's always perilous to count on one branch of government to rein in another branch of government. So that can't be our last and final hope, the Supreme Court, that is, but it's an intervening hope. And so I'm optimistic that they'll at least hold the line to some degree for a number of years. All right, everybody, I hope you enjoyed the show. If you did, don't forget to like and subscribe to help us spread the message of freedom. As always, you can find the show on YouTube, Rumble, Facebook, X, and on all the most popular podcasting platforms. You can also find me on X at Forge of Freedom and at forgeoffreedom.com. Until next time, everybody, remember, you are the Forge of Freedom.